Well, thank you very much, Jim. Thank you, Greg, for having me here today, and to the Centre for Independent Studies for hosting us. Just to clarify, Jim, I have met people who said they're not in favour of free speech. Unsurprisingly, it was at a university. In fact, I spent my early university days, my teeth were cut fighting for free speech, actually, in various different conferences where people said they advocated for fair speech and not my right-wing notions of free speech. I'm also very glad to have had your commentary and only to have attracted your criticism, because ordinarily you start your conversation with saying that my job should be abolished. And so, it's nice to perhaps be in a club, and just against the test, except for the incitement to violence provision, of which I'm a waverer, but on balance in favour of restriction, we are on the same page about the things people can say. It is, of course, a delight to have been invited to speak here at this important event on the topic of the current state of and threats to free speech in Australia. Let's get straight to the point. The state of law is disappointing for a Western liberal democracy. The state of preparedness to defend the principle of free speech is even poorer, and the threats are many, growing, and often come from those whom you would hope would be best defenders of free speech. Of course, Australia has limited legal protection for freedom of expression. We have a deference towards its preservation through the common law. We have a limited constitutional protection for political speech. But the primary instrument we use to preserve more open and free expression is in fact something we give far too little deference towards. That is political culture. We take it for granted. And culture is heavily built on what we educate Australians about what they should value. The test for protecting free speech is, of course, twofold. First, we protect free speech by having a political system that ensures that all expressions are legal unless they are made specifically illegal. Second, we have a political culture that has learned from the broad philosophical liberal Enlightenment thinking that speech should only be restricted if it causes substantial harm or infringes on the rights of others. And Jim's just given a very good explanation of that, so I needn't go into it. Yet we are increasingly breaking from these important traditions. Australia is becoming a society adrift. Individuals are being betrayed by too many in positions of power and authority who are intellectualising censorship and taking populist stands rather than defending ancient truths. It will take nimble and considered action to reclaim our political culture and to preserve our freedoms. And part of that sits at the heart of education. The practical reality is children are never taught the value of freedom, the importance of rights in schools. So one of the things that we are doing this year under my guidance as Human Rights Commissioner is actually developing resources that will go into every single Australian school on the importance of human rights and freedoms. The 800th anniversary of Magna Carta provides the perfect catalyst to bring about this change. In grade 6, kids are taught about Magna Carta. In grade 10, they are taught about the Universal Declaration of Human Rights. They are not taught about anything or the connection between these two very significant events. I am going to fix that. Debates over free speech have always been on the frontiers and the clash of civilisation. During the negotiations over the Universal Declaration of Human Rights, Stalin's Soviets fought to have restrictions against hate speech, have them included, but ultimately they were defeated thanks to the efforts in countries like the United States, the UK and Australia. At the time, Eleanor Roosevelt described hate speech as, quote, extremely dangerous and likely to be exploited by totalitarian states for the purpose of rendering the other articles null and void. Australian delegates astutely observed that, quote, morality should not be, quote, legislated. Tragically, the Soviets then won during the debates surrounding the International Covenant on Civil and Political Rights, and that is why we have restrictions today around principles such as hatred. It seems now that free speech is once again a battleground for civilisations. Maybe it never stopped being so. Extremists are claiming legitimacy to the murder of cartoonists for expressions they find deeply offensive. Yet, scarcely, this time, there are too many prepared to apologise rather than robustly defend free speech. Now, I know Greg said he didn't want today to focus on the Racial Discrimination Act, but the practical reality is the reforms or failed efforts to reform it last year is very instructive. I suspect to those in the audience the need and the case to reform a law that makes it unlawful to offend, insult, humiliate, intimidate a person on the basis of their race, colour, national or ethnic origin is obvious. But it clearly isn't to many other people. Against our free speech test, 18C creates two very serious issues. The first is its hard censorship by using the law to impose censorship, and it's a low and subjective test that applies. The second is soft censorship by having a vague and subjective free speech exemption through 18D, which allows 18C violating expression if it is done reasonably and in good faith. Importantly, 18D isn't really an exemption. It is a permission. 18D permits expressions and reverses the very principle of a free society, that all acts are legal unless they are explicitly made illegal. Advocates for the maintenance of this law have argued that its removal will license bigotry. Of course, such a proposition is simply absurd. For starters, we just need to test it out against other forms of expression for identity groups. There is no equivalent law for any other identity group like 18C. More importantly, we have accountability mechanisms outside the law. Speech sits on a scale. Nothing needs to be done to respond to civil and polite speech. Free speech only needs to be defended when it crosses the line of social acceptability, not the excessive use of please and thank you. As Adam Smith argued in his theory of moral sentiment, the wisdom of our democratic history behind us tells us that a good society is created not by pursuing the illiberal with tribunals, punishments and bans, but the morality that grows out of the desire of people to be validated by the good opinion of others. There are, of course, countless contemporary examples where, in the face of unacceptable conduct and increasingly being aided by technology, Australians have chosen not to be passive bystanders. They stood up for their fellow citizens against behaviour they deem to be unacceptable. Criminal penalties only apply at the far end of the scale. In Australia, we have them for things like incitement to violence, but we also have them for urging violence on the basis of religion, political views and racial groups. And of course, as a consequence of last year's changes to national security laws around urging terrorism. Advocates for the maintenance of 18C have wrongly asserted that it's justified because it has an empirical case to support it, because there were 3 significant federal inquiries that preceded its introduction. In fact, none of the inquiries actually recommended its introduction. None. In fact, the Human Rights and Equal Opportunity Commission, the predecessor to the Human Rights Commission, expressly recommended against such a low threshold as would allow complaints for, quote, for hurt feelings and, quote, injured sensibilities. Importantly, the law has now been used for purposes that even advocates for it argued it would not be used for. In a 1994 article in the Age newspaper, 2 high-profile advocates for 18C wrote that it would, quote, apply to the skinhead on the street yelling racist names and other insults at an Asian man or a woman in traditional Islamic dress, not newspaper articles or anti-immigration pamphlets, end quote. History shows that, of course, these people were dead wrong. And, of course, it is now time to bring the law in line with their claims. It remains a very serious disappointment that the federal government botched efforts to reform this law last year. In a political culture that values fairness and justice as well as rights, which is the context in Australia, the federal government simply inadequately prepared the case for change, the grounds for reform and the tone of debate, despite there being a broad consensus that there was need for reform. The divergence remains primarily about the reform that should be implemented. Many people have told me they don't understand what is wrong with 18C. So let's not mince words. We have codified emotive and subjective tests in law to justify restrictions on our most basic liberties, and when that happens, we should not expect justice. Instead, we are handing over the so-called appropriateness of the exercise of our freedoms to gatekeepers to decide what is permissible and what is not. And the practical reality is that we have seen huge double standards. We see at universities significant professors standing up and making claims that many people would find offensive, yet many people sit there in silence and say nothing. We've seen more recently political parties directly inflaming prejudice against particular groups or ethnic groups. And again, the people who ordinarily cry out against this kind of conduct stay silent. Why would we establish such a principle in law? The prevalent, selective and confected outrage culture that now dominates too much of Australia's mainstream political discourse shows soft censorship is too common on serious issues in need of discussion. Ineloquent expressions are no longer seen for simply being crude. Instead, outrage is used as the basis to delegitimise any discussion on an issue itself. This culture is bad enough. It should not be backed up with the firm hand of law. Let's also not delude ourselves into thinking that we are winning this fight. Last year, I conducted a nationwide consultation on human rights and responsibilities and what they mean in 21st century Australia. In fact, I hosted one of my events at the Centre for Independent Studies. While some understood the importance of free speech, in practice, many groups also wondered why 18C only applied to matters of race. Why wasn't it broader and covering other identity groups? The calls were for more restrictions on free speech, not fewer ones, to expand their restrictions. Race has merely become the market leader. Other identity groups are now following. And to be fair, it doesn't make an awful lot of sense why you can't offend somebody on the basis of race, but go nuts on people with a disability or on the basis of their gender or sexual orientation if you're completely indifferent to free speech. Of course, if the same standard applied to everybody, we would have nothing but a straitjacket society, unable to discuss anything controversial. The horrific attacks on Charlie Hebdo earlier this year should have been an opportunity to refocus the mind of the federal government to reform 18C. They didn't. Yet Charlie Hebdo perfectly demonstrates the necessity to defend and preserve free speech from principle, not the selective application based on the fads of the day. Those that cried "Je suis Charlie" were rightly horrified that people could be murdered for their expressions. Yet, if those same people concurrently support 18C in its current form, they are prepared to use the law to punish and at the extreme end jail the same individuals if they refuse to self-censor. Some people have wrongly asserted that Charlie Hebdo would not have been caught in 18C's nest. They're wrong. There's a strong overlap between race, culture, and religion. Charlie Hebdo would have been a perfectly legal publication in Australia, but it would have been caught in 18C's hard and soft censorship. Charlie Hebdo included covers that covered matters of race, religion, and importantly, ethno-religious subjects, and not just Muslims. As the explanatory memorandum to the Racial Hatred Act 1994 outlined, quote, "The terms ethnic origin and race are complementary and intended to give a broad meaning. This would provide the broadest basis for protection of peoples, such as Sikhs, Jews, and Muslims." Of course, the explanatory memorandum does not mean that's how the law will be interpreted, but it can be used in a law's interpretation. The first stop of any complaint under 18C is the Australian Human Rights Commission. The legal advice I have received from the Commission is as follows, quote, "The approach that the Commission takes to complaints that it receives is that it is insufficient for the complainant merely to assert their Muslim faith to fall within the definition of ethnic origin under the RDA. However, if the complainant can show that he or she is part of a group with a sufficient combination of shared customs, traditions, and beliefs derived from a shared history, this may be sufficient for them to constitute an ethnic group. In short, it is possible to claim an ethno-religious Muslim heritage and be covered by 18C. Of course, the test that is then applied is whether it is exempted under the reasonably and in good faith permissions under Section 18D of the Act. This, of course, can only be tested on a case-by-case basis, but includes standards such as being about a legitimate issue of public policy discussion and seeking to minimise offence. So let's take an example from the famous edition that was released after the... I realise that some people may find this cartoon offensive. On the left, we have a clearly Arabic man who, by reference to Ramadan, we are led to assume is Muslim. On the right, we have a lesbian woman. The text translate, obviously, Ramadan is Ramadan. The body text above the woman says, I eat, think of Mr. Slocum from Are You Being Served? When I want. Below on the T-shirt has, oh, come back. There we are. The T-shirt says, neither whores nor submissive. So does this cartoon meet the 18C threshold? Based on the reception it probably receives from Arabic Muslims, it could well offend or insult and possibly humiliate. So would it be exempted under 18D? That is, of course, debatable. I'm not sure how it is discussing a legitimate public policy issue or seeking to minimise offence. I'd argue it is flagrantly dismissive and contemptuous of the subject matter, the cultural attitudes and norms of the Arabic man in the interest of robustly defending the liberty of lesbians. This cartoon highlights a myth that surrounds justifications for censorship, that censorship favours the weak and the powerless. From a justice perspective, 18C, of course, does make a certain degree of sense if racial or ethnic groups are only the recipients of unsavoury conduct. But the practical reality is that racial or ethnic groups are just as capable and do denigrate other minorities and subcultures. For almost all of humanity, gay and lesbian people have sat at the bottom of society's social structures and have often been victims of more dominant cultures. Anglo culture has and still does denigrate gay and lesbian people. We are now bucking thousands of years of cultural tradition and breaking with that past. But many cultures are not. I'm sure many of you would have noted the horrific crimes committed by ISIS against gay men who are being murdered by being thrown off buildings and the like. As shocking as these murders are, they are hardly new. Iran actually does this lawfully all the time. They just do it by the most brutal form of hanging. Yet when we create legal protections to stop something like offence or insult or humiliation of somebody on the basis of things like race, colour or ethnicity that are connected by culture, we are granting legal shields, both for that which is legitimate, but also for what is illegitimate. Only the free and open contest of debate protects the vulnerable. 18C is, of course, not the sole test of advancing free speech, but it is an important test about whether we are able to reclaim foregone liberties. It is equally important that overly generous defamation laws are reformed to raise the standards from triviality towards what is a material loss to an individual from an earned reputation. Sadly, I can't see any of this significant reform happening soon. There simply lacks a broad consensus for reform, particularly in a society that, as I've already said, values rights, fairness and justice. In fact, I see the reverse. During my consultations, all I've heard continuously is how much we need to rein in social media and protect people from the horribleness of the internet. We're now hearing disturbing utterances that the federal government is considering criminalising hate speech in an attempt to silence Hizb ut-Tahrir. We don't have details, but introducing criminal penalties against racial and religious hate speech is as disturbing as Hizb ut-Tahrir themselves. I don't want there to be any ambiguity about my view of Hizb ut-Tahrir. They are a disgraceful group who are attempting to dress up extremist ideology as a legitimate political and social cause. It is nothing of the sort. But rather than being silenced, they're a group that we should keep a very close eye on. Pushing them underground makes that pretty difficult. But tackling them through censorship won't stop their cause. They are motivated by mad political ideas. Censorship does not stop their ideas. Instead, it legitimises these ideas to their supporters and their sympathisers. If they're prosecuted for expressing these views, they are also given a platform to express their madness. You can kill people. You can't kill ideas. You can only discredit them. As Peter Grester argued in his National Press Club speech last week, closing down debates exacerbates problems and doesn't make them go away. Worse, using an emotion such as hate as the basis of law only escalates attempts at censorship. The term hate speech doesn't mean anything. It's a vacuous phrase designed to encapsulate any expression from another person you don't like. This was on full display after SBS recently refused to run an advertisement by the group Australian Marriage Forum. The AMF is an entirely legitimate political group founded to preserve Australia's existing marriage laws. They sought to air an advertisement that expressed that view. In response, SBS censored their advertisement and refused to air it during the broadcast of Sydney's Gay and Lesbian Mardi Gras. If SBS had a policy of not broadcasting any political advertisements, then their action would have at least been reasonable. But we all know they would have had no hesitation broadcasting a pro-reform advertisement on exactly the same subject matter. In response to the broadcasting of this advertisement on Channel 7 and Channel 9, my office received a number of complaints, saying the advertisement was a form of harassment against same-sex couples, their children, and many people decried it straight up as hate speech. Let's remind ourselves of what this advertisement was advocating: that children, quote, wherever possible, should have a mother and a father, and hence marriage laws should remain unchanged. Literally, it was advocating, I would argue poorly, for the current law. Innovative? No. Insensitive? Maybe. Hate speech? You've got to be kidding. Yet that was the argument. And once we establish the emotion of hate as the basis and case for censorship, we have to accept it will have disturbing, unintended consequences and impose both hard and soft censorship of legitimate topics to the harm of society, intellectual progress and individual dignity. Thank you.